Andrew C. McCarthy is a contributor to Fox News, but he's an editor at National Review, and he is one of the two participants in the McCarthy Report, a podcast I never miss. I listened yesterday to that which came out the day before, and I listened this morning to today, so I'm fully caught up. Andy, thank you for joining me.
Hugh, it's my pleasure.
I want to start with yesterday, the International Emergency Economic Powers Act of 1977. That was, now, I think it would be, if it gets to the court and it's been brought in the First Circuit, there'll be standing issues. If it get past standing issues, let's just say they get to the merits. IEEPA was passed to curb the ability of presidents to do exactly what Donald Trump did. In fact, it was an immediate response to Richard Nixon's 1972 shock, where he laid down a 10% tariff on everyone. Do you really think the court is going to give a green light to the use of a statute that was intended to curb the very thing that President Trump did?
No, I don't. In fact, I think the case against it is stronger now than it's ever been because of the court's major question rule. You know, the idea that if you look at other statutes, Hugh, where the president's allowed to impose tariffs, there's very strict limitations on all that stuff. The thought that in the IEEPA, Congress intended not only to give the president this tariff power, which isn't mentioned in the statute, but to do it basically with complete carte blanche, with none of the strings that are attached in other tariff litigation, to me it's a preposterous proposition. And I just have to say, my own view of the statute, for what it's worth, is I think the Supreme Court should have thrown the whole thing out once the legislative veto was found in the Chadha case in 1983 to be unconstitutional, because that statute was meant to have a control on the president's ability to find that there was an emergency and to issue sanctions. Congress was supposed to be able, within 30 days, to countermand the president without having to get the president's signature on a piece of legislation. I think once the court said that was unconstitutional, the legislative veto, then the whole statute should have gone, because without the legislative veto, you have exactly what we have now, which is a president wielding powers that nobody ever contemplated and nobody able to do anything about it.
There's also, I believe that subsequent to Chadha, the statute was amended to allow for a joint resolution. I think that's what happened. But it's got limits. If it's only for emergencies, it can't be for everything. Every country in the world, I mean, that list that the president brought out is 75 or 80 countries. That's not an emergency. That's an underlying fact of economic life. And if they want to address it, I think you ought to go to Congress and get the authority to do so. So I understand your argument. The Chief Justice likes to punt because he thinks it's his constitutional role to punt and leave it to the political branches to quarrel it out. But I think even institutionalists, I think they're at least Barrett's an institutionalist, Kavanaugh is sometimes an institutionalist. Even with the originalists and the institutionalists, you got the three liberals will vote no. I think there's maybe not 9, maybe they'll lose 1 or 2, but I do think it's in trouble when it gets to the courts.
I hope you're right. I'd like to be wrong about that. The thing I have to say, and maybe this is just my sort of default prejudice, I've said this in a number of contexts. I think the framers would have thought it was very weird that the Article 1 branch, which it gave an arsenal that was better than any other branch of the government got to combat excessiveness either by the courts or by the executive. The idea that the Article 1 branch needs the Article 3 branch to do its heavy lifting is something I think the framers would have found very strange. And for someone like Roberts, who has a lot of influence on the court, to have twice now in the last 4 or 6 weeks, whatever it is, a proposal made to include in legislation a control by Congress withdrawing some of this emergency power that the president has, and to have the Republicans in Congress not let that be voted on, if I'm the court, I'd be pretty aggravated about that.
Now, this morning's McCarthy report, which is fascinating because you're critical of the president and the administration response to the ruling 9-0 that they must facilitate the return of Mr. Garcia. I just used his last name, Garcia, from El Salvador. And Bukele yesterday, he doesn't speak English. If he had simply said, "It is not in my country's interest to return him, I'm not going to do it," that would be the end of that. But he said that ridiculous comment about it, "I'm not going to smuggle someone in." Do you think that might just be a butchered translation of what he's trying to say?
No, because all the English speakers said absurd, preposterous things.
Well, no, but it's only Bukele matters.
Right. Yeah, I mean, Bukele was actually pretty tame compared to Steve Miller and Pam Bondi. So no, I don't think it's a translation problem. I think it's a gaslighting problem.
But if he just says, "It is not in my nation's interest to return Mr. Garcia. He's a member of MS-13. I will not be returning him," that ends it, doesn't it? Because the court's not going to order him to do anything. They don't have any jurisdiction to do that.
Hugh, this is all it's all a big distraction. There's an agreement. There's a written agreement between the United States and El Salvador. Any court would want, in a situation where there is an agreement between two sovereigns, including the federal government, about the custody of prisoners, any court would want the details of the deal between the sovereigns. And it's been publicly reported on the basis of commentary by Bukele's own Ministry of Public Affairs that the American government paid Salvador $6 million to house 300 prisoners for up to a year, by the end of which the United States government determines the disposition of the prisoner, which means the federal government, just as it does when it has agreements with the states to use state detention space, the federal government still has dominion and control over the federal prisoners. That's the only thing that matters.
Well, this is the wonderful and terrible thing about executive agreements. I go back to Dames and Moore. They're worth the paper they're written on. They can be torn up and amended the next day. And if Bukele says, "Oh, this wasn't what I intended, and I'm not going to abide by that," and in fact the administration is winking and nodding at him, I think the court is blocked out as surely as if Joe Petonio pancaked someone on a pulling guard. It's really, the courts can't get into stuff like this. I'm pretty...
Well, no,
go ahead.
I don't agree with that. I think the courts can't make Salvador and the United States either have an agreement or not have an agreement. But once they make an agreement, the details of which affect the rights of people who are legitimately before federal courts because they have cognizable claims, then what the United States government can do is subject to judicial review.
Andy, I've only watched the Supreme Court once, Dames and Moore. I happened to be in town for a summer clerkship, and the guys at Baker and Bott said, "Here's a ticket, go down, watch Dames and Moore." So I went, and I couldn't believe what I was hearing, because all these lawsuits against the revolutionary government of Iran had proceeded at great lengths, and some people had judgments, and the executive order swept away all those judgments of the United States courts saying, X, Y, and Z Corporation was owed $18 million from Iran. And they just said, those don't count. They're going to The Hague. At which point I realized executive agreements are very, very powerful, and Dames and Moore stands for the proposition that they win. I just don't think that if Bukele says no, the court's going to try and sanction anyone on Team Trump. Now, there are ways that you get back. If you swear at the umpire under your breath, you can get thrown out of the game, or he can just call every ball a strike, right?
Yeah, but I think nobody is saying, and I'm sure the Supreme Court is not going to say, that it can order Bukele to do anything. What it can do is order the United States government, under the terms of the agreement it made, to facilitate this guy's return. And then we'll see what the government does. Look, as Rich and I discussed today, the fact of the matter is, as Hamilton said, the court is the weakest branch. It can't force anyone to do anything in the sense that it doesn't have the sword and it doesn't have the purse. But
that's what happened in the
before,
Civil War. Tawney told Lincoln to produce the body. He was sitting as circuit judge, but Lincoln just blew him off, non-acquiescence.
Right.
And I think that's what's going to happen here, and I'm not going to be upset. I am going to be upset if they deny minimal habeas to anyone now, because the 2 9-0s, and they're different ways of counting, but they've twice agreed, 9-0, that everybody in the United States, no matter what your status, is entitled to de minimis habeas proceedings, which I think you got to show up in a court somewhere and you got to have an argument that it's not me. You got the wrong guy. John Belushi and Carrie Fisher in Blues Brothers. You got to be able to throw everything at the court or at a court. Do you think that's like the bottom line? Everybody gets notice and a hearing, and the Supreme Court was very explicit. After the date of this opinion, everybody gets notice.
I think that's absolutely true for anybody who is still in the United States to whom these proclamations might apply. So when we're talking about the proclamations, I guess what we mean is the Alien Enemy Act, and to the extent the State Department in February designated MS-13 and Tren de Aragua as terrorist organizations. If you say, that's not me, I'm not a member, you're entitled to notice and an opportunity to be heard on that point.
Yeah, I think they will get that. Andy, the part of this morning's McCarthy report that had me shaking my head a little bit is I think you suggested Team Trump is trying to break the court. I disagree. I think there's a phrase in the Patrick O'Brien novels about Jack Aubrey and Stephen Maturin from the Napoleonic Wars, coming in high, which means coming in real hot, trying to aggressively push the law. I think they're coming in high on the Alien Enemies Act to get as expansive an interpretation of their authority under that, to get to Zone 1 in Jackson's 3-zone theory, and that they'll live there, wherever they get. But they're coming in demanding as much deference as possible. And in the Trump versus JGG, they got a nod from the per curiam that the Alien Enemies Act is entitled to, has got very limited judicial review. So I think they're going to get there. I think they're going to find out that if you're in the country and the Secretary of State says your being here is contrary to the best interests of the United States foreign policy, out you go, green card or not. I think they're aiming for that, Andy, and I wouldn't be unhappy if they got it.
Well, let's clarify, Hugh, what I meant by break the court, because I think I'm not sure listeners are going to understand exactly what that means. What I said is that what I think Trump is trying to do is eviscerate the limits on his authority. He is trying to accumulate as much power in the executive as he can. And what that means is to, in a very public way, show that the Supreme Court can't force him to do anything, which is basically what we've been talking about for the last, 10 or 15 minutes, whatever it is. That's what I mean by break the court. I don't mean break the court as an institution that can decide cases, which is its main job. I mean break the court in the sense of, well, I didn't say break the court, but what I mean is to eviscerate the court as a meaningful check on executive authority, along the lines of, what we were talking about before, which is that the court doesn't have purse strings and it doesn't have force. It's got judgment. And if its judgment is not going to move players in the system because they don't feel they'll pay a political price for blowing off what the Supreme Court says, then the Supreme Court is done as a limit on executive power.
But they are not blowing them out. The Mr. Cahill is getting his day in court in New Jersey or someplace, and other people are getting their
court.
Yeah, they're getting what they asked for because of the court's rebuke in D.C., even though they lack jurisdiction subsequent in Trump versus JGG. I think that message is received, but I still think they're going to push every envelope to see how much they can get. And after you let 20 million people and overwhelm the system into the country, by not enforcing the law. Doing that doesn't bother me, and I'm a rule of law guy. I think the IEEPA is unconstitutional as applied, but I don't think using the immigration authorities to the maximum extent as are legal, meaning minimum habeas. Do you think that's okay?
I do. Look, I was
You're a prosecutor.
immigration hardliner before these guys were. And I think that, actually, along those lines, I think Judge Boasberg was right in the sense that the administration is foolish to rely on the Alien Enemies Act, because I think they're going to get more judicial review on the underpinnings of that than I think you do. The court talked about the Ludecky case written by Justice Frankfurter in around 1950 or so, I think it was 1948, where he basically said, we can review the underpinnings of this act. Like, is there a war? And by extension, they'll be able to say, is there an invasion or is there a predatory incursion? What Judge Boasberg said is, look, you've already designated these two organizations as terrorist organizations. The courts aren't going to look behind that. The only issue on what you and I agree is limited habeas review is, am I a member of Tren de Aragua? Am I a member of MS-13? The court is not going to review whether the State Department was right in saying that those were terrorist organizations.
Now, an even broader, the AEA, I think the ruling in Trump versus JGG was extremely limited judicial review of the AEA. But in green card cases where the holder isn't AEA
Right.
covered, you covered the process today. I'm going to go to a break and then ask you to explain to the audience what rights are owed, because I don't know. What rights are owed to a green card holder? They have the highest legal status in the United States, but it's not a citizen. What rights, if we want to throw you out, do they have? This I know nothing about, and Andy knows a lot about because he dealt with a lot of people in the United States on permanent residence who happen to be terrorists. And they have a set of rights that was added to by the Supreme Court in the terrorism cases of the aughts. Andy, what do we owe people who've got a green card?
So it really depends on the context. If you go back to the Cold War, especially the middle of the century, cases like Eisentrager, which is probably
I don't know
1953 or so, what the Supreme Court says is the alien improves his lot in terms of rights on a sliding scale as he integrates further and further into our society. And what that really means is as you go, the lowest part of the scale is an illegal alien who's here, right? But if you get someone who's here on a tourist visa, and that becomes a student visa or a work visa, and then you comply with the conditions to get a status adjustment up to lawful permanent resident alien, as you go along that scale, in many contexts, you improve your array of due process rights to the point where a lawful permanent resident in many instances, for example, tax law and securities law, is considered a U.S. person. There's almost no daylight between their rights and the rights and obligations, and those of the citizen. But in some contexts, everybody's rights are the same. So, for example, if you're thrown into the criminal justice system, the government has to prove guilt beyond a reasonable doubt, regardless of whether you're a citizen or an illegal alien. So that's basically what it depends on is the context. And here, what we're talking about is statutorily, the Congress has endowed the Secretary of State with the authority to boot aliens out of the country regardless of what class they are in, if they engage in criminal activity, if they associate with terrorist activity, or if in the judgment of the Secretary of State, the person's presence and activities in the United States are detrimental to American foreign policy interests. And then the Secretary can kick you out even if you've engaged in what's basically protected, what would be First Amendment protected speech or association if it was engaged in by an American citizen.
Does that standard apply outside of AEA designated groups?
Yes, it's any
Wow.
any alien it's a separate category. It's called foreign policy in the immigration law. But what it says is that any alien can be booted out of the country on these grounds. But the Attorney General, the Secretary of State, if it's going to be based on activity that an American would have a First Amendment defense against in a criminal case or another kind of proceeding, the Secretary of State has to personally file something with the court that says, I have looked at this and I've personally decided that this person's presence here is detrimental to U.S. national security.
Okay, get the auto pen out. I'm lying. I'm sure Marco will do his best to look at all thousands. It's a shot across the bow of everyone. Andy, you're younger than I am, so you weren't at the DOJ in 1984, I don't believe. Were you?
I was, yeah. That's when I started.
All right. Do you remember? I started there in 1984. The fallout from Bob Jones versus the United States. The university had lost its tax-exempt status, and there was, in the 1983 decision, there was much hue and cry about what to do next. And they, of course, had failed to come into the modern era. They admitted blacks, but they didn't admit them on an equal basis on the campus, so they lost their tax-exempt status because they violated the Constitution and the Civil Rights Act of 1964. Harvard is now up on a high horse. I think it's the same case. It's just anti-Semitism, not discrimination against blacks. What do you think about the president's throwdown on Harvard today?
I like the idea of going after all of these universities on anti-Semitism grounds and DEI grounds. I don't like doing it by executive order. I think that's a bad practice. We have a civil rights division in the Justice Department, and I think it would be perfectly appropriate to turn them loose on these universities. I also think, like, to the extent the president says endowments ought to be on the table, I think endowments ought to be on the table. But I don't like, whether it's in the context of the universities or the law firms or these individual guys like Christopher Krebs, I don't like these Bill of Attainder type executive orders that lay out a bunch of accusations of misconduct and then impose sanctions. And in terms of what's going on with the universities, it reminds me of what I most dislike about the Obama administration, which is that its Justice Department would open a pattern or practice investigation in civil rights on a police department or a municipality. None of those municipalities have enough of a budget that they can go toe-to-toe with the Justice Department, and they extort them into signing consent decrees where the municipality agrees to a bunch of stuff the government could never impose by regulation or legislation, but because it's a statute, they basically strong-arm them to agree to a bunch of stuff that isn't good for the public interest and that the government shouldn't be allowed to do.
Well, that's why I like them going after Harvard. There's no question that, they're not the federal government, but they got a lot of resources and they got a lot of lawyers. Yep. And everyone's going to sign in as amicus. I'm just hoping they filed an amicus brief in Bob Jones, arguing that Bob Jones should lose their tax exemption. I don't know that they did. I'm just praying that they did. But Leo Terrell is the special counsel in the Civil Rights Division. Harmeet Dillon has gone there. I think they're going to go for a consent decree, such as we saw in the aftermath of Brown v. Board with school districts that were recalcitrant. And it might reach down to the hiring and firing, like we hired and fired teachers in districts that weren't compliant, the construction of new facilities, the eradication of programs that were anti-Semitic. I think it can go pretty far, Andy, and I think the rot is deep in some of these institutions. It certainly is at Harvard. I was on campus 2 summers ago, and I'm just amazed at how radical it is. And I don't even know how to convey it to people how radical it is. I had to agree to go to a reunion, I had to consent to a half dozen different stipulations about what I would say and do on campus. That's how crazy it is. It's just sort of a mind virus has got there. And digging that out may be difficult. I do worry about individual targets, but Harvard can take care of itself, right?
Yeah, I think your point there is well taken. What I don't like about these things, Hugh, is when it's not really an arm's length situation. When you're dealing, as the government is, when they're dealing with municipalities that really are not in a position to litigate them. But, Harvard can go toe-to-toe with these guys. I just would like to see them do it the right way. I'd like to see the Civil Rights Division make clear that, number one, it's open for business and taking its obligations seriously, but also that unlike under democratic regimes where it's basically the province of democratic interest groups, they're the only ones that you can activate the civil rights laws for, I have a lot of confidence that Harmeet Dillon would take the position that the civil rights laws apply to everyone, which includes Jewish kids walking across the campus trying to get to class.
Yeah, and I think a consent decree does not offend me because it's not an assault on the First Amendment. It's not assault on anything. It's the upholding of the Civil Rights Act of 1964 with regards to Jews. And we wouldn't even think twice if it was some recalcitrant backwoods tiny college in the middle of nowhere that was refusing to admit Muslim students. We'd come down on them like a ton of bricks and everyone would applaud. But if Harvard is not doing anything, I can't get out of my mind, Andy, and I'll leave you with this, get your comment on it. In front of my freshman dorm, a Jewish kid got assault and battery by a Harvard law student and surrounded by 6 people and not allowed to proceed. That's prima facie evidence of a poisoned environment. I can't get it out of my mind.
Yeah, both that they would do it and that they thought they could get away with doing it. You know, let's face it, in modern times, if you change the facts and it's a black kid who's being stopped from, you know, enjoying the fruits of a college experience, the Justice Department would come down on them like a ton of bricks, and nobody would expect anything any different. And my only point is that quality of justice ought to be available across the board to everyone, not just special interest groups that progressives like.
I agree. Do I get my 3rd McCarthy report every week? Have you and Rich worked that out yet?
Boy, he's got to up the ante if he wants 3 out of me.
How about just one on baseball? You guys might want to cover the Guardian someday. I just want to say it's always the Mets and the Yankees, the Mets and the Yankees, the Mets and the Yankees. Honest to goodness, you lose half your audience in the first 5 minutes, but I listen because I learn. Andrew C. McCarthy on X. The McCarthy Report is must listening if you want to be smart about the legal issues